Hello, everyone. My name is Kirk Mylander. I'm the general counsel at Citycounty Insurance, and I'm going to be talking to you today about the Supreme Court case of Johnson versus Grants Pass. It was about the homeless camping controversy that came from here in Oregon and had the potential to spread nationwide. Fortunately for us, it only spread through the western states, the Ninth Circuit. So this is what happened because of the case. Our cities, they just felt like they couldn't enforce camping ordinances. People were just allowed, homeless people, to camp anywhere. That homeless people could basically get a pass on every kind of law regarding their behavior in a public park. Like they were allowed to litter and urinate in public. They couldn't be forced to move to a safer location. So some would camp like in parking spots along the street or across a sidewalk. The case made something out of these laws couldn't be enforced against involuntarily homeless. And everyone wanted to argue about what involuntarily meant. Unfortunately, it just meant they're homeless, which we'll get to later. Then it said that you couldn't enforce camping laws against the involuntarily homeless unless there was adequate shelter. And adequate shelter, what does that mean? Well, it pretty much meant a low barrier shelter matched to fit whatever restrictions the homeless person had. And we couldn't burden them at all, like for a dog or a family or smoking marijuana. They didn't have to give up anything for an adequate shelter. Then finally, in Oregon, there was a statute passed to try to match the case that was in effect. And it said that time, place, and manner regulations have to be reasonable. So there's still lots of debate about that. And then now and then, cities were asking, can we clear out homeless camps? So that continues to be an issue today, although it was more acute back then. So, what happened? Well, this is the bottom line. The Supreme Court of the United States reversed the Ninth Circuit. And the Ninth Circuit ruling had prohibited all enforcement of anti-camping ordinances against homeless persons. And the rule was against homeless persons when there's no other place in the city for them to go. And the thinking here was that if you are homeless and you have nowhere to go, then it's cruel and unusual not to let you lay down and sleep on public property, because you have to lay down and sleep somewhere. You can't just make it illegal for them to exist in your town. So that was the thinking of the case, even though the legal reasoning was a bit different. And as I said before, now that this case is gone, Oregon is left with a kind of reasonableness statute, which your state is not, because no other state has that. Unless you're listening from Oregon, then you know that you have that statute. So the problems with camps that we experienced, and cities, especially like Seattle, San Francisco, Los Angeles had, is that they spread disease. There was lots of hard drug use, lots of trash, lots of stray needles, and needles spreading around into private property around the camps. I personally had phone calls from someone whose backyard backed up to a river and a park on a river. And so their backyard had needles in the grass. And this person wanted to have grandkids over and felt like they had lost the ability to use their own backyard because of stray needles in the grass. Loss of parks for kids was another frequent complaint, like that public parks that had play equipment and had been places for children to gather were now basically homeless camps with tarps and trash and needles. So there's also a safety issue apart from kids, and that was fires. a lot of folks in these camps would light their drugs or start small fires to keep warm, and those would turn into larger fires and sweep through or spread through a camp, and then everything burns down. So not safe. Additionally, traffic was blocked and sidewalks were blocked. And I experienced this personally walking downtown where there's multiple tents on the sidewalk, and I had to step off the sidewalk out around cars that were parked, get past all the tents, and then back onto the sidewalk and continue where I was walking in Portland. And you look at that and you think, well, what if you don't have the ability to just pop on and off the sidewalk? And there actually was a lawsuit against the city by disabled individuals saying you are discriminating against me on the basis of my disability by failing to keep sidewalks clear for my use, because they couldn't just pop off the sidewalk, down a foot or so to the street and then jump back on. So lots of issues there. And then another problem with these camps, probably the biggest problem is from the view of anyone who wants to help the homeless people, is it does isolate them from services. There's no way to push them into services. And that's one of the things that being able to enforce camping laws does, is it enables you to nudge these folks into services. So going back a little bit, before we got to the Supreme Court, the first case in the Ninth Circuit, and here are the states of the Ninth Circuit, was Martin versus Boise. And then that was followed up by Johnson versus Grants Pass real quick thereafter. And Johnson versus Grants Pass is the one that went to the Supreme Court, ultimately went our way and overruled Martin versus Boise. So just a bit of background to see how we got to where we are. In the Boise case, the court said that the Eighth Amendment, which bans cruel and unusual punishment, it said that the imposition of criminal penalties, so not civil, just criminal, for sitting, sleeping, lying outside on public property, when that is applied against homeless individuals, that is cruel and unusual, that they have to have somewhere where they are able to go. So it didn't say that camping laws are de facto cruel and unusual against everyone, only against the more narrow population of people who are homeless. So then how did that change with the city of Grants Pass? So in 6 weeks later, after the Martin v. Boise case was handed down, 3 people brought a claim against Grants Pass, and I mean, shock of all shocks, they had the same lawyers as the Martin v. Boise case. And in this one, Grants Pass is a town of about 38,000 people in southern, more rural Oregon. It's not part of the Portland metro area. It's about a 4-hour drive away, and kind of a mountain town. And so it gets cold there in the winter. And in that case, these 3 people brought claims, and they alleged that not only were criminal sanctions cruel and unusual punishment, but civil citations, just a ticket or a civil fine, that was cruel and unusual punishment as well. And the court said that there was a mathematical ratio that prevented a city from enforcing any of its homeless camping ordinances or camping ordinances against homeless. They don't have to be homeless camping ordinances. So what they said is, as long as there are fewer shelter beds than involuntarily homeless people, the camping statute cannot be enforced. And involuntarily homeless just means there isn't a place that's perfectly matched to that person. So if I am homeless and I have a dog, or I have a spouse or girlfriend, and the shelter doesn't allow, separates genders, which they often do for safety, and we don't want to be separated, then I'm involuntarily homeless. If I have a dog and I don't want to give up the dog, and the shelter has a bed available, doesn't allow dogs, I'm involuntarily homeless. If I'm smoking pot and don't want to stop, or cigarettes and don't want to stop, or the shelter has a religious message and I don't want to be exposed to that, you're involuntarily homeless. If there were shelter or places to camp available on federal land nearby, those didn't count because they were outside the city limits. And I mean, like, literally abutting the city limit. The court would not consider those available camping places. And then the city had a warming shelter, and the court would not consider that available because they didn't have beds in the warming shelter. So the Johnson versus Grants Pass case extended Martin v. Boise to saying that, all civil penalties of any kind are not, violate the Eighth Amendment, and that there was no more nighttime enforcement and no more daytime enforcement without 24 hours notice. So someone basically could set up camp for the day, get notice, move to another place after the day was up, and then they would get notice. And so they were able to camp all day, was the practical effect. Another thing that was unique about Grants Pass extending the Boise v. Martin case was it allowed for class certification and a right to protection from the element. So whereas Boise said, you could camp, Grants Pass says you have a right to shelter, which is different than just allowing someone to camp. The Ninth Circuit's rulings, these two cases combined, really did paralyze local government. There's this unworkable focus on, like, what is voluntary? And we had all these cities, calling people like me saying, well, this isn't voluntary because they dropped out of a drug treatment program, or it's not voluntary because all they have to do is sleep in a different section than their girlfriend. Another thing that we saw over and over again was cities just throwing up their hands and saying, there's nothing we can do here without getting sued, so we're doing nothing. And the result was inaction. There's threats of more litigation for pretty much any solution other than taxpayer-funded homes, being built for the homeless. That was really the only solution that the folks behind these lawsuits wanted, and they were open about it. I mean, I was in a meeting kind of debating this statute that Oregon passed, and they just out and out said cities need to build housing, not just shelters, housing for homeless people. So what happened next in the Johnson versus Grants Pass case, everybody is just completely frustrated by it. And the city petitions for the Ninth Circuit, which the case was decided by three people, three judges, panel of three. So you can petition for the full circuit, all the judges on the court, to rehear the case. So they petitioned for that, and the Ninth Circuit denied it by one vote. So we were one vote away from having the whole Ninth Circuit review the case. However, what was good is all the judges in the minority, and barely a minority, a lot of them wrote very strong dissenting opinions that were pretty much asking the Supreme Court to take the case. So one of them here was Judge Smith, and he read he wrote that Martin and Johnson use a misreading of the Supreme Court precedent to require unelected federal judges to act more like homeless policy czars than Article III judges applying a discernible rule of law. And that one got a lot of press because that's what it felt like, that the ability of local government officials making the rules that apply to their unique situation and their unique jurisdiction, their local area, they had the ability to craft what would work for them, ripped away and handed down by, unelected policy czars. And so there was a lot of support for asking the Supreme Court to take the case up. And they did. And the argument at the Supreme Court, which I got to attend, which is super fun, and you should totally do it if you get the chance. It's amazing. The room is amazing. There are all the 9 judges up there, and you feel like, at least I feel like, I'm seeing NBA celebrities. It's like better than seeing LeBron James or something. But there was a hot argument for anyone who listened in, and the attorney for our side really got ripped by a couple of the justices, basically as just being cold and mean toward anyone whom was involuntarily homeless and literally had no other place to go. And we didn't argue that there were other places to go for most of these people because they wanted to keep the focus on the Eighth Amendment. Like, does the Eighth Amendment actually prohibit enforcing generally applicable camping laws? Or does the Eighth Amendment only prohibit types of punishments? So the idea was to try to sidestep kind of the local particulars and argue just about what the Eighth Amendment does or does not prohibit. And so the decision, which was authored by Justice Gorsuch, said some good things. And it quotes a lot of city leagues around the country. And they said homelessness is an acute, multifaceted problem and not given to any single solution. And it's like, we couldn't agree more. We need to have the ability to evaluate this locally. And then they said the Ninth Circuit inappropriately limited the tools available to local governments for tackling what is a complex and difficult human issue. And that is so true. That's what our people felt here in Oregon, in the states around us. And I am very glad for those of you out of the Ninth Circuit that Johnson v. Grants Pass did not become the rule of the land for all the U.S. So I say we, I'm kind of taking a little bit of credit there. It wasn't. So the Eighth Amendment was the focus of the decision. And the court said that the Eighth Amendment, it's about methods of punishment. It's not about substantive limits on what types of things can be punished. And, what was at issue here? Modest fines, small ones, and short jail terms. And the argument was that's cruel and unusual as applied to homeless. And then the other argument is, no, that's not cruel and unusual at all. In fact, those are common punishments nationwide. There's nothing cruel and unusual about those. And looking back, the reason this slide is up is this picture. In the 18th century, English law, formally tolerated, but not in practice, but formally allowed for some kind of barbaric stuff, like disemboweling, quartering people, public dissection, and burning people alive. Now, it had fallen out of favor, and that's where the unusual part comes from. So these things were cruel because they were still formally possible, and unusual because they had fallen out of favor. And there was some debate about whether the Eighth Amendment was even going to be necessary, because the thinking was something like this would never happen again, these kind of punishments, in any kind of civil society. But the framers took no chances and put that into the Eighth Amendment to make sure those things never came back. And they were all specifically about, types of punishments that really were kind of grotesque. I kind of alluded to this earlier, but the Supreme Court, there was really a groundswell of support for people asking the Supreme Court to take up the case. And this is one of the things that I was most proud of. We worked the phones to try to get support, and it wasn't hard, actually, because it's like my circuit might become like ruled by the same opinion as the Ninth Circuit. Oh my gosh, no. And yeah, we'll do a brief to try to get that changed. So there was a very diverse set of amici, meaning friend of the court. They just file something saying, yes, Supreme Court, please take this case. It's super important. So you had like some conservative legal groups, and then you had the governor of California, Newsom, the city of San Francisco, Los Angeles, Phoenix, League of Oregon Cities, every neighborhood association in all of San Francisco, I tell you, pitched in. Just a multitude of different folks saying, the Supreme Court needs to take this up. And I think in some ways, the diversity showed that this was not an issue about ideology. It was an issue about like practical livability and local governments. So where are we now? The Supreme Court, did reverse the Ninth Circuit. And like I said earlier, Oregon has this statute that we're left with. The Ninth Circuit, its ruling is gone, but it's actually not over. This Johnson versus Grants Pass case is still pending. It was sent back down to the local court, and Sotomayor, in her dissent, basically just laid out a roadmap where people can continue to file lawsuits on these issues based on things other than the Eighth Amendment, cruel and unusual. So she said, hey, the excessive fines clause is fertile ground for further lawsuits on this. The 14th Amendment due process clause is also grounds for lawsuits on this. The Fifth Amendment due process clause is also grounds. And then in Oregon, we have this statute that has already generated some lawsuits. And that is the wave that is already coming. There are the statutory claims, and then also under the 14th Amendment, the state-created danger claims, which basically just says if the government takes action, you don't have a right to help from the government, but if they do show up to help, they can't like hurt you and make it worse. And that's why some local governments have said, I don't want to like build a camping area for the homeless with improvements like outhouses and sinks, because if it's not patrolled with security, we're going to get sued for allowing injury there, like making it worse by collecting criminals there. And like, do we need to do background checks on everyone who is admitted to the homeless camp to protect, let's say, women and children from some sexual predator, and forcing them to congregate in one local place. And then the big one that we're seeing that you could see very soon is Americans with Disability Act claims by homeless individuals, saying that because of their physical or mental disability, the camping statute as applied to them is illegal, and they should be given an accommodation of waiving the camping statute and allowing them to keep right on camping. And just so you know, I'm not making this up. Here is an actual suit against one of our, if you picture the southern westernmost corner of Oregon, the beach right up against California, that's where this is, Curry County. And they say Curry County is subject to the Rehabilitation Act, the ADA, that the plaintiff was a qualified individual and he's partially deaf, permanently paralyzed. And then it goes on to say that the statute should be waived. And so a little bit about this case. He was set up to be a future plaintiff along the lines of the Johnson case. And he told the sheriff's deputies this while his body camera was running. So it's like on video. It's not like some weird rumor by me or, you know, defense lawyers around here. It's him telling the deputies this, why their body cam is running. And they were offering to move him and his stuff from land that had been leased, it had been public, leased to a private entity. And it was really to get them off because it was causing people to not go to the retail stores that were right next to it. And so it had become private land. And there was public land nearby, like 100 feet away. I mean, you can look at a map and it's just right there. And they were offering to move him and all his stuff over to the public land that was right close by. So he, you know, that could be an accommodation. And he said he had to check with his lawyers because he knew he needed to be punished. And so he couldn't accept anything other than punishment. And then he says, I have to get a ticket so there's damages for my lawsuit. And he goes on and on about this. And so finally, they issue him a citation and they say, we don't want to do that. We would much rather just help you. It's much easier for us. And he's like, I'm sorry, but I need a ticket so that I have damage for my lawsuit. So they write him a ticket finally and then help him move his stuff because otherwise he wouldn't let them help. And so this case, we have a summary judgment motion pending, you know, saying we did accommodate him by helping him. But the ADA, this is the new frontier for these homeless cases. And the ADA applies nationwide. So it could be tried in your area, although we have some real activist lawyers seem to be on the West Coast on this one. This slide is just to not lose focus on the idea that this is the progression that we really do want to see. You know, people go from homeless and unsheltered to homeless and sheltered. And that's where that transition is where most of this case comes in, you know, pushing them into services, into the services that are around shelters. And then from there, once they're stable, getting them into subsidized housing. And then from there into market rate housing and freeing up that space for other folks. And so wanted to include this just to like acknowledge that this is the overall goal that we're shooting for, but there's a lot of fighting about step 1 and 2 here. And a lot of the advocates on the other side just want homeless and unsheltered straight into subsidized housing and are trying to really shut down any alternative other than their choice. And they want to kind of set their choice in concrete via litigation. So a few recommendations for you as we wind up. Consistently enforce rules around conduct other than sleeping or camping. So I call these the 3Ds: drug, defecation, and dogs off leash. There are, I mean, you'll just find those consistently. Now, you will also find consistency littering and a lot of it. And, some prostitution that does happen. And then we really want to give opportunities, use this new space for local government to craft local solutions to local problems, to push folks into meaningful engagement with services. And, the goal there is to get them off the street, to not let them, fester in disease and filth in these tents. And then this should go out without saying, but it happens. Some of this stuff is so gross that people make jokes to kind of make light of it and get through it. And so they say stuff that when it's recorded in a public meeting or in a email that is public record, it comes back to haunt them and makes them look very bad. So don't say stuff that could be perceived as insensitive in public meetings or in email. It will bite you. And then stay involved in lobbying efforts, or at least monitoring your legislature to make sure that you don't have one that is like Oregon's and tried to codify a bad case, and then you're stuck with part of it even after the case is overturned. So that is the sum of our presentation. I thank you for your time and attention, and I'm available for questions if anyone has them.